Good afternoon, everyone, and welcome. Great to see you after a long weekend. Hope everybody had a good, safe, long weekend. Today, Dave Ledeen is going to talk about the basic of contracts for waste management and fiber optics, which affect many units across the province. We've worked with Dave. He's been a business member and a partner of CHOA for many years, and he handles a lot of these types of agreements for strata corporations, and I couldn't think of anyone better to actually speak to the event. So as we go through, if you have any questions, put them in the Q&A. We do not have engaged response back and forth. The participants cannot communicate for your protection and safety, so you can't be identified. And we will answer questions at the very end. But if there's something that's pertinent as we go along, we'll certainly ask Dave if he can address the question for us. My slides won't move.
Hey, Tony, just a quick update.
Into the chat, not the Q&A. Sorry. Put your questions into the chat. I said Q&A. Thanks, Daryl. Our sponsor this week is Bromac, so many thanks to them for participating and sponsoring our event this week. And just a little note on privacy. While you may be putting items into the chat for questions, try to leave personal information out of it if possible. Again, it's secured. We're not sharing it between participants, so there isn't much risk of your personal information, but we try to manage excuse me, your confidentiality at the best at all times. These sessions don't constitute legal advice because they're very generic, they're very broad, but they help you to understand the contract relationships that occur. So without any further delay, Dave, all over to you.
Thank you very much, Tony. I'm welcome everyone. I'm very pleased to be here today with you. I just want to say quickly, last week, Jennifer Neville spoke about heat pumps and commended CHOA, and I certainly completely agree with the comments Jennifer made. I think very highly of CHOA. I think the contribution that CHOA makes to education is really, really amazing. So this is an overview of the presentation, and so there's really two parts to the presentation. There are lots of different kinds of strata properties in BC, and there are lots of different kinds of contracts that strata properties need for their operations. So the first part of the presentation applies to any kind of a contract that any strata property may need for its operations, and that will go right up to legal authority of the council. Second part, we're going to be looking at waste management services contracts and also fiber optics contracts. Tony, if you could move to the next slide, please. What is a contract? So there's many different types of, many different definitions for a contract. I think the easiest way to understand it, to understand what a contract is it's an agreement between two or more parties, which creates obligations for each party that the courts will enforce. The key word there is enforce. So some contracts that are made, they're not enforceable in the courts, and a contract is just like a bylaw. It's the exactly the same concept. A bylaw of a strata corporation may not necessarily be enforceable. I've given you the first part of section 121.1 of the Strata Property Act, clause A, which makes it clear that a bylaw is not enforceable if it contravenes the Strata Property Act, for example. The last part of this slide, it's important to know that contracts, there's no law that says a contract must be in writing. Obviously, and I've given you a citation to a recent BC Supreme Court case, which found a verbal contract to be enforceable in the courts. Next slide. Why are contracts important? They are very important. And the reason is that if a party breaches his or her obligations under a contract and the other party suffers a loss, the courts can and do order the party that's in breach to pay compensation to the other party for breaching the contract. And so it's a liability of a strata corporation. If a potential liability, if they do breach a contract. And the legal word for this kind of compensation is damages. I'm going to be talking later on in the presentation about a case I came across. It's a case 2013. It started off in the small claims court. It went to the BC Supreme Court, Super Save versus TriStar Cap and Garment. It's a very important case. Everyone needs to be aware of the case because it deals with a contract where there was a service provider to provide services to a strata corporation, in this case, Super Save. In this particular case, TriStar signed the contract with Super Save, changed its mind, said we're not going to go ahead. And Super Save sued TriStar in the small claims court. They lost. They appealed to the BC Supreme Court. The BC Supreme Court said the contract was enforceable, and TriStar was ordered to pay damages. Next slide, please. Here we're going to look at some basics of contract law. And the first part is formation of the contract. How do we know if there is a contract between two or more parties? And so there's three essential elements: offer and acceptance. There has to be an offer before there can be acceptance. If there's no offer, there can't be acceptance. And the offer has to be accepted by the party that makes the offer. So that's the first part. There must be offer and acceptance. The second part, I put the legal word in there, consideration. I want you to think of value. So the idea of consideration, that's the legal word that's used in the courts and in the textbooks, is does value pass between the parties? At the bottom of the slide, I've put what is consideration, an exchange of value between the parties. So for example, when you go shopping and you're looking for an item of clothing in a clothing store, every item of clothing that is there that's available for purchase, that's an offer by the store. And then when you pick up the item of clothing that you want to buy and decide you're going to buy it, that's acceptance. And then when you purchase the item, that's an exchange of value. The third element, certainty of terms. What that's really about is meaning. Is the meaning of the contract clear enough? And there are many, many cases that go before the courts, and that's the issue before the court. We have a contract in writing, so we know what the words of the contract say, and the question is the meaning of those words. Are those words sufficiently? Is the meaning of those words sufficiently clear to constitute certainty? And if not, the court will find that the contract is not enforceable. The most common example of consideration or value will be an exchange of agreements between the parties to do something. And so, for example, in the waste management services contracts, all service contracts, the service provider agrees to provide a service of some kind to the strata corporation, and the strata corporation agrees to pay the service provider money in exchange for receiving the service. The next part is I want to talk a little bit about the word term, because it has two meanings. So if I were to say to you a term of the contract, you're going to think of, well, that means a clause in the contract, and that's correct. That's correct. The important thing to understand here is that what term of a contract means is that every contract has a start date and an end date. And the contract becomes effective legally on the start date. The time period between the two dates, the end date is called the term of the contract. So I've given you an example here of a auto renewal clause. This comes from a waste management services agreement that came to my attention on one of my files. This is exactly what the clause says, word for word. So you'll see it says here, this agreement is for a term of 5 years. So it starts on a start date, and then it goes for 5 years, and then it ends after 5 years. It goes on to say, and this is the wording that you'll see in all of the contracts that have an auto renewal clause. It says it shall be automatically renewed for successive 5-year terms without further action by the parties. Then it goes on to say in plain English that the other party to this contract, in this case, it would be a strata corporation or the receiver of the service, can cancel the contract, but there's only a 30-day window. So they would have to give a notice to the service provider not more than 120 days before the end date of the contract, and not less than 90 days. So obviously, that is a very, very narrow, and it's called the cancellation window in the clause. It's obviously a very, very narrow opportunity for the receiver of the service to be able to cancel the contract. And I'm going to be talking more about these auto renewal clauses later on in the presentation. So yeah, so these are my tips for auto renewal clauses. Ideally, you want to delete the clause, and because that way, then nobody has to spend any time diarizing dates to make sure that you don't miss this cancellation window. Having said that, and we'll be talking about this later on in the presentation, some clauses in contracts are fundamentally important, and some are less important. If I was acting for a strata corporation and they were asking for my advice and they were getting a lot of resistance from the service provider about deleting this clause, I would say, well, leave the clause in. Just make sure that you have a really long cancellation window, and it's got to be at least 3 months before the end date of the contract. And I think that would be fine. So like I say, ideally delete the clause, but if you have to, make sure that you have a cancellation window that's at least 3 months. Finally, the second point, actually, I'll just, that's okay, I'll talk about that later. Yes, thanks, Tony. Number 2, I've come across auto renewal clauses, which when you read the clause, it doesn't give the receiver of the service the right to cancel. The only party that can cancel the contract is a service provider. So if you're going to have an auto renewal clause in the contract, got to make sure that your strata corporation has the right to cancel. Thanks, Tom. Damages. This is a fundamental principle of contract law. And so the question is what happens if a party breaches his or her obligations under a contract? So that happens all the time. Very, very common. So if there's a breach and the innocent party suffers a loss, and then this is the legal principle that applies to all of these different types of contract breaches, the damages that the innocent party is entitled to is the amount of money that is required to make the innocent party whole. Put the innocent party in the same position as if the breach of contract had not occurred. So that's the fundamental general principle of damages. Damages is a whole separate area of the law unto itself. There are textbooks at the legal textbooks that deal solely with damages for breach of contract, and they're of course quite voluminous. The second principle that applies to damages is mitigation. So where there is a breach of contract and the innocent party suffers a loss, the law requires the innocent party to take all reasonable steps to minimize its loss caused by the breach of contract. Next clause, I'm going to spend some time about this. This is something that is perhaps a little bit difficult to understand. So we talked about damages for breach of contract. So there's an expression in law called liquidated damages. What does that mean? So the law permits parties to agree in the contract itself on the amount of compensation that the party that breaches the contract must pay to the innocent party if the contract comes to an end due to the breach. And so this amount of money is called liquidated damages. And we're going to, in this TriStar case, I'll be talking about shortly, the contract in that case had this exact clause, or had a clause in it for liquidated damages. So that's the concept of liquidated damages. I'm going to spend some time on this TriStar case that is there before you. This is from the BC Supreme Court decision. So I got to say, when I first came across this case, it's a 2014 case of the BC Supreme Court. I read the case. I said to myself, this can't be right. Doesn't make sense. And I thought, I came across this case in I think 2 or 3 years ago. And I thought, for sure, this case is going to will have been considered by subsequent court decisions, and it will have been, and subsequent decisions will have said, no, it's wrong. And so I was very, very surprised to find out that this case has been considered in many, many different decisions after 2014 by the BC Supreme Court, and all of the decisions have said that it's right. So this is a case that illustrates you have to be very careful when you sign contracts. What happened here was TriStar had a contract with a company that is now Waste Connections for the provision of waste management services. And that contract with Waste Connections, the end of that, the end date of that contract was July 1, 2011. January of 2011, SuperSave approaches TriStar, says we can give you a better deal, and the council or TriStar decided to sign a contract with SuperSave, and they did that on January the 12th of 2011, which is almost 6 months before the end of the Waste Connections contract. The contract that TriStar signed had this clause that I have put on the slide there for you. And there's not another clause that says in the contract, essentially, if the contract comes to an end because TriStar decides to breach the contract, then this liquidated damages clause applies. And so it was on January 24th, less than two weeks after they signed the contract, notice was sent to SuperSave saying, we've changed our mind. We're not going to go ahead with the contract. So I'm going to read this from the slide here. This is from the BC Supreme Court. On first impression, TriStar submission has some merit. Seems unfair that a person who signs a contract immediately decides to not go ahead with the contract, receives no benefit from the contract, should have to pay the full contract price for services it does not want and never receives. So what happened here was, second here. So the court in TriStar said, and I'll read this out loud here, I conclude that the income stream lost over the remaining 2-year term of the contract, well, it was the entire 2-year of the contract, amounts to a genuine pre-estimate of damages and is not a penalty. So in this case, the court found that the contract was enforceable and that the damages were not a penalty. The clause was enforceable, and the court ordered TriStar to pay to SuperSave the full amount of the contract price, which was around a modest amount of money. I think it was around $1,200. Next slide, please. So the other possibility with a liquidated damages clause is that it's a penalty. So there's two possibilities. It's a fair estimate. It's a fair estimate of the damages, and therefore it is enforceable, or it's a penalty. If it's a penalty, then the clause it's either unenforceable, or the courts will reduce the amount of the damages payable by the party in breach. And the legal authority for the courts to do this, to make that declaration of unenforceability, is Section 24 of the Law and Equity Act. Next slide, please, Tony. Are contracts negotiable? I'm going to spend a bit of time on this because this is very important. The answer is yes, they are negotiable. There's one exception. Contract cannot override legislation. And there's a quote here I'm going to read to you, and then I'm going to elaborate a little bit about this. This comes from a recent BC Supreme Court case involving a service provider of waste management services. It says Revolution describes its pre-printed form, standard contracts, as a template, which serves as the starting point for negotiations with its customers. Mr. McRae, president of Revolution, states that it is quite common for Revolution sales representatives to modify the pre-printed terms through negotiations with customers. So what's very important here is I've been a lawyer for a long time. I've worked with contracts for many, many, many years. And the number of times that I've come across a situation where the lawyers on the other side, or the party I'm dealing with, says to me essentially, the contract that we want your client to sign is a standard form of contract. No one's ever had a problem with the contract. It's never been changed. No lawyer has ever had a problem with the contract. There's no need to do anything other than to sign the contract. And so that is just simply bullying in the commercial marketplace. You can ignore that. I suggest that you keep a copy of slide 15 and this quote from this case. And if anyone ever says that to you, you can just read back this quote from this BC Supreme Court case and say, yes, contracts are negotiable. Next is, what is the legal authority of the council to enter into contracts? And I've given you Section 38 of the Struck Property Act, which makes it completely clear that a Struck corporation has the legal authority to enter into contracts that the Struck corporation needs for its operations. So there's two different types of approvals that are required for a Struck corporation to enter into a contract. So, for example, we're going to be looking later on in the presentation at waste management services contracts. A majority vote resolution of the council is sufficient. The legal authority to enter into that kind of any kind of a service contract does not need a 3/4 vote resolution of the owners. With respect to fiber optics contract, it's a very, very special kind of contract. It's a special kind of alteration agreement. In all likelihood, it's a disposition of the common property, because the third party is going to be making an alteration to common property, and it requires a 3/4 vote of the owners. And I've given you the references in the Strata Property Act and Section 29 of the Interpretation Act, which explains the rationale for why I am saying that it's likely a disposition of common property. Next slide, please. So this finishes the first part of the presentation, which is which applies to all contracts, or any kind of a contract that any Strata property may need to have for its operations. Now we're going to look at two specific kinds of contracts. The first one, waste management services contracts, which many Strata corporations, unless you have a really, really small Strata property, it's going to have a contract for waste management services. So in the slide here, I've given you this is word for word from a contract that I came across recently on rate adjustments. And so what the clause says, and there's also, it goes on to the next slide as well. What the clause says in plain English is that the service provider reserves the right to charge whatever rates the service provider may decide, whatever those rates may be. When I first started looking at these waste management contracts and I came across this clause, I thought to myself, wow, this is incredible. I mean, it's just amazing that, that people would firstly, it's surprising that it would be in the contract, but in any event, there's lots of contracts out there that have been signed where this clause has not been changed at all. And so obviously the receiver of the service, the Strata Corporation, is in a very difficult situation. They're at the mercy of the service provider. Next slide, please, Tony. So this is the same clause. And it goes on to say, this is just more of the same. It says, where the circumstances described above do not apply, contractor may also, upon written notice to the customer, adjust the rates here. And it goes on to say they can increase them for other reasons. And then the customer has the right to object. And if they don't do so within 15 days, that's a 15-day objection period, then they're deemed to have agreed to the increases. So very, very further on in the presentation, I'm going to give you some tips about these rate adjustment clauses. So the most important thing that you need to understand is if you're looking at signing a contract with a service provider for waste management services, the first thing you need to do is, most importantly, is does the contract have a rate adjustments clause? Probably it does, but if it does, then I have advice for you further on in the presentation. Right of first refusal. This one is really troublesome. So what this says, and so many of these waste management contracts, actually, in fact, this applies obviously to waste management contracts because I've seen them in most of the waste management contracts that I've seen, but it could be in other service contracts that you may have. What the clause basically says in plain English is that if you have a contract with a service provider and you decide we don't want to deal with this service provider anymore, we want to change service providers, you can't do that unless they agree, and that they have the right to force you to continue to do business with them in the future. That's what this right of first refusal clause says. So that's obviously very troublesome. Next slide, please, Tony. So this particular clause, it's called a restraint of trade clause in contract law. And so when I first came across this clause, my client we had to research this, and we did, and I was very surprised to find out there's a Supreme Court of Canada decision, 1978. I've given you the quote here, and I'll read it to you. It says, a clause in restraint of trade is enforceable only if it is reasonable between the parties and with reference to the public interest. So the bottom line here is that this kind of a clause may be enforceable against the Strata Corporation. So very troublesome, very worrisome. I've spoken to some Strata property managers that I do business with on a regular basis about waste management services contracts, and they say the biggest problem with them is performance, is that they'll have a schedule for delivery and to pick up the waste, to clean up the bins, and then they don't show up, and they say, oh, well, the driver was sick, or there's a mechanical breakdown of the vehicle. So got to be very, very, very careful with this clause. Next slide, please. So here are my tips for waste management services contracts. Never sign a contract for more than 1 year. And for the reasons that I've explained. There's no, and you can absolutely insist it's no more than 1 year. There are lots of different service providers for waste management services. There's smaller, there's big ones, there's smaller ones, but absolutely do not sign a contract for more than 1 year. Auto renewal clauses, I've talked about that, and you can, I've already addressed that in previously in the presentation. With respect to rate adjustments, you simply want to amend that to say no surcharges will apply during the term. And then that would prevent the service provider from attempting to charge back any rate adjustments. If it's only for 1 year, that should not be something that the service provider would object to. If the service provider refuses to go with no surcharges will apply during the term, then you have to go through the rate adjustments clause word for word and get an agreement on, okay, if the service provider is going to have the right to adjust the rates, well then on what basis? And then lastly, delete the right of first refusal clause. You don't need to have the problem of spending time dealing with that clause if you want to change service providers. Fiber optic contracts. I would like to take this opportunity, firstly, to salute Tony for raising this issue in the industry. What happened here, the background to this is one of the service providers, this would have been probably 2014, 2015, came out with a standard form of contract between the service provider and a strata corporation that would enable the service provider to provide fiber optic services to owners in the building. And Tony was given a copy of this standard form contract, had a quick look at it, thought this looks very, very one-sided. I think we need to educate the public here. And he asked me to write this article in the Choa Journal, which I did. And I've given you the reference there if you want to go to the article and to the Choa Journal, and you'll find the article that I wrote about this particular agreement. That was very effective in the sense that this particular agreement the service provider did, as a result of this article in the Choa Journal, agree to make it more fair and take out some of the things that were egregious. And so the agreement, the last time I worked with this agreement, it had been made into a much more fair agreement for the strata corporation. There's another article that about this agreement that Tony wrote in the Condo Smarts, and it highlights the MDU access condition. And so what that access condition, I've on the slide there, no service provider can prevent or restrict another service provider from delivering fiber optic services to owners in the same residential building. I'm just going to read to you. TELUS reported its earnings last week, and then there was an article about TELUS's earnings, and then in the article about TELUS's earnings, there's a reference to a recent decision of the CRTC, February the 3rd of this year. There was a dispute before the CRTC involving Bell, and I'm just going to read you from the article. Here's what it says. It says, TELUS praised a CRTC ruling that allowed Canada's largest telecoms to continue selling internet service in regions where they don't own fiber networks by paying the local incumbent to use their infrastructure. So just to make this clear, let's say you have a building where TELUS has installed the fiber optic infrastructure. And then owners who live in that building are able to sign up with TELUS and get the fiber optic services. So if another service provider decides that that service provider wants to be able to offer fiber optic services to owners in that same building, then that service provider can go to, for example, TELUS or Rogers or Bell and say, we want to be able to provide services, and then they have to the party that installed the infrastructure has to come to an agreement of some kind with the other service provider to use its infrastructure. The first thing about fiber optic contracts is so I'm going to start off here with, this is the first part of the agreement that I've worked with in the past. It's on fiber optic network agreements. The intent of this agreement is to permit the service provider to have access to the common areas of the building, to install telecommunications equipment at no cost to either party. So what this is it's an alteration agreement, and the Strata Corporation is going to give a third party, not an owner, a permission to make alterations to the common property. And so the most important part of the agreement is that the agreement needs to have clauses like an alteration agreement between the Strata Corporation and an owner that give the Strata control over the installation work that is to be performed by the service provider. Next is repair. This is a very important clause. So once the installation is done, the service provider is going to have its infrastructure installed in common property. And so there needs to be a clause in the agreement that says the service provider agrees to repair at its sole expense any damage to the building that's caused by the operation of its infrastructure. Ownership of equipment. This is very important. The agreement needs to say that the infrastructure, the equipment, installed equipment, any other equipment that is installed by the service provider remains the property of the service provider, does not become a fixture. If it were to be a fixture, then it becomes the property of the Strata Corporation, and then the Strata Corporation is responsible for it. Next is removal. The clause needs to say that upon termination of the agreement, when the contract ends, the service provider must, within a certain period of time, I would suggest certainly no more than 90 days, remove the equipment. Next, indemnity. This is a critically important clause, must be included in a fiber optics contract. This clause says, in plain English, that the service provider will make the Strata Corporation whole if the Strata Corporation suffers any property damage or any kind of loss that's caused by the service provider's infrastructure. And when I first started working on this type of agreement and looked at the standard form contract that had been prepared by the service provider, it had an indemnity from the Strata Corporation in favor of the service provider, and of course, no indemnity from the service provider in favor of the Strata Corporation. So never, never, never agree to give the service provider a reciprocal indemnity. There's no reason, no justification whatsoever for the Strata Corporation to give the service provider an indemnity. Exclusion of liability in favor of the Strata. This is also a critically important clause. And so an example would be, what this clause says is that if something happens in the building and there is damage occurs to the service provider's infrastructure, then the Strata Corporation is not responsible for the damage that occurred. And so I've given, this is from a clause that I drafted it, and it was accepted by the service provider. So I put in here sprinkler, drainage, or plumbing system. So obviously if there's a a water leak, or there's a sprinkler damage, or some kind of problem with any of these systems that damages the service provider's infrastructure, then without this clause, the service provider would look to the Strata Corporation to be made whole. So once again, critically important clause must be included in a fiber optics contract. And that completes my presentation.
That's excellent, Dave. So just before we jump into the questions, I think the reality check for most strata corporations is that strata councils are volunteers, property managers are overworked. I rarely ever see all of the service agreements and contracts assembled with a summary of their renewal dates and expiry dates and provisions of how to do this. So I think the first step for strata corporations is collect all of your contracts and service agreements into one place where every council member has access to them, for starters, because they're the decision makers, and closely look at them and look at your renewal terms and conditions, because and get it on a website, either hosted by someone or for the strata corporation, because strata councils change, property managers change. No one monitors the contracts unless you have a pretty well organized strata corporation. So these evergreen contracts just keep flowing over and over and over, which, maybe that's what the strata wants, but maybe it isn't what they want and they're unaware of it, which is why so many of them end up on our doorstep. And so, from a reality check perspective, I think that strata corporations would save themselves a lot by simply organizing all of their service agreements into one location where it could be monitored.
I completely agree. That's excellent advice. I highly recommend that all strata corporations and strata property management managers do exactly what Tony has suggested.
I think the other thing,
obviously, some strata properties have more service contracts than others, and I think it's exactly what needs to be done for every strata property in BC. Yes, absolutely.
I think the other thing that strata corporations don't put into context is, I often hear, well, why would we get legal advice on this? Our fee is only $180 a month. Well, your fee might be $180 a month, but you've just signed a 5-year automatic renewing contract. And in 5 years, that contract actually has a value of over $10,000, not $180 a month, which you're committed to. For a small amount of money and a percentage of what that contract is, get some legal advice to protect yourselves, because it's not a $180 a month contract. It's a $10,000 contract or greater in most cases. And, I think it really serves strata corporations well if they manage the understanding of what that global impact of those contracts is.
Of course, I agree. Yes, absolutely.
Daryl, you've been monitoring questions?
Yes, I have. And one, we'll get to some, but I think one that really popped out for me was one where, on installation of fiber optics, the latest that people are hearing from providers and their subcontractors is that there's no contract at all, just a right of entry to install these fiber optic systems.
That's just completely false.
There you go.
Totally.
Super. Good to hear a positive.
Totally wrong.
All right. And so, Tony, you answered the one about the the bylaw. So can the strata have a bylaw requiring the strata council to seek legal advice on any contract that exceeds a certain period of time or amount?
I think so. My call would be is the bylaw this would be about expenditure of money. The bylaw, I think the bylaw would need to say that something like, for a contract that has a value in excess of X dollars, then the strata corporation doesn't have the authority to enter the contract without legal advice. I think that's probably what the bylaw would say, something like that. Tony, you probably gonna have some.
Yeah, no, it could. The challenge with that is, again, going back to, are the current Strata Council aware of the bylaws? Many of them don't have a copy of the bylaws. Is somebody actually monitoring that? And it's about the corporation entering into the contract, which is through the Strata Council. But if the Strata Council violates it, what are the consequences? It's not an impact to the service provider because we have a provision within the act that protects service providers in an event of a defect of the corporation. So it doesn't hinder or alter the service provider's contract or their entitlement to the terms and conditions. It's just simply an enforceable condition against Strata Council. But Strata Council are the ones who decide about enforcing bylaws. So it then becomes a vicious circle about who's enforcing bylaws against who. And, an owner certainly could be taking it to the CRT if it's not being enforced, but that would just become an enforcement order is all it becomes. So, rather, you can do that provided everyone has a very well-informed and educated understanding of what those obligations are. But with the constant change of strata councils and managers, I wouldn't rely upon that to be your safety net. Your safety net is get good people on strata council, make sure every council member has a copy of every contract and service agreement, and review them annually so you understand what's happening. In my building, we have a summary page. The summary page has every service agreement listed on it, talks about the term, the fees, and when the expiry or renewal date is, so we know when to target it for review or updates. And, a simple summary page can go a very long way to protecting your strata corporation.
Great. Awesome. One of the other ones that talks about, so the articles that are quoted are very helpful, but warns about pitfalls. How do you recommend moving forward with modernizing our equipment with new internet technology like fiber? So is there more of a process about proactively adding that equipment or, reinvesting into your building?
Well, the council would reach out to all of the service providers in BC that provide fiber optic services. I know that there are more than the major three telecommunications companies, and seek out proposals.
Great.
One of the things you said earlier on, Dave, was that there's no standard form of contract in these relationships and agreements. But that language, we see it all the time in every part of services provided to strata corporations. They always call them either standard form of agreement, a copyright agreement, a proprietary agreement. And you're right, the expectation is that the consumer will kind of be duped and they're just going to believe that this is what is imposed and that there's some level of authority that regulates it. There isn't. It doesn't exist. Every contractor will negotiate their contracts based on their own service agreements.
So that's exactly right. I do want to say one thing that so every contract has some clauses in it that are fundamentally important.
Yeah. And
then there's going to be clauses that are important, but they're not fundamentally important. And then there's going to be clauses that are less important. And so contracts are negotiable, as I've indicated. And the best example would be auto renewal clause. Is it fundamentally, is it a deal breaker for a strata corporation? If they really want to do business with that service provider, for that service, and the service provider says there must be an auto renewal clause in the contract, my advice, fine, make sure that you have at least a 3-month cancellation window, maybe 6 months, and then the council has to then diarize that so that if they don't want to renew, they have to give the notice.
Super. One of the questions about waste management service contracts up here was an interesting one. It's how do strata corporations deal with strata managers or strata brokerages that want to consolidate their condo clients' contracts into one master agreement. And, you know, is there a benefit to that? Or, you know, they say it'll lower fees. You know, what are the pitfalls? What do strata councils need to think about? And maybe is there a pushback for that?
To be honest, I mean, I find that a little bit of a strange question. I mean, but what it's essentially saying is that a strata property management company would collect, I don't know, 10 different versions of waste management contracts and put together a standard one. I mean, if that's the case, everything I've said in my presentation applies to that.
Yeah.
To that standard new standard contract that's put together by the strata property management company.
Yeah. So again, I think we fall back on the idea that get that legal advice, right?
Dave, I think that also goes to the attempt to try and enjoin multiple strata corporations into mutual agreements where there is potentially some beneficial negotiations. But the downside of that is strata corporations don't really have the ability to be enjoined to collective liabilities with other strata corporations unless there is a covenant or an easement between the parties. And so there's kind of a slippery slope that happens there.
Yeah, I think that so. If there are red flags, and so what Daryl just described to me, if that exists, to me that's a red flag. Why is the strata property management company doing that?
Mm-hmm. Very interesting question. Yeah. Back now, Bearland stratas, we haven't really said much about this, but Bearland stratas with underground services, this person has a concern whether or not the fiber company can install the new conduit in existing channels, and if not, and damage they might do to paved roads, sidewalks, or even damage to the wiring in those conduits. You know, kind of any idea how they can protect themselves from that kind of thing, maybe under the contract or terms in the contracts?
It would be in the terms of the contract with
Yeah.
the service provider.
Okay.
And the other term that needs to be in there is that there should be absolutely no penetrations to the building envelope, no staples or screws to the siding or cladding, no attachments to the building exteriors. You know, it seems like a great idea today, and 20 years from now, when you're doing window replacements and discover a great amount of rot because siding has been breached or cracked because of installations, think seriously about what the implications are going to be.
That's a very good comment, Tony. I totally agree. Excellent.
Mm-hmm. I think we've captured pretty much.
Well, and we're right on time. So
Yeah.
there we go.
Yeah.
Perfect. Dave, thanks a million.
You're most welcome.
Very nice.
My pleasure.
And anyhow, and thanks again to Browmac for their sponsorship and BC Housing for our ongoing research partnership that we have with them. You'll see a number of new guides coming out with the BC Housing research programs in the journal and programs that we've been working on for the last few years. We finally got a bunch of things published, so they'll be coming out shortly. So everyone, thank you very much for joining us today, and we hope everyone has a very good day.
Thank you, Tony.